Okay, we're now ready to start today's web panel discussion on best practices for sharing IP rights in the life sciences industry. Good morning, good afternoon, and good evening, everyone. I'm Steve Joseph, the Vice President of Market Development here at ShareVault, and I'd like to thank all of you for joining us today for this event. In a moment, we'll get started, but before we do that, I'd like to first cover some logistical items, introduce the sponsors of this event, and also introduce our moderator who comes from Women in Bio. As you can see from the agenda, along with the panelist presentations, there will be discussion questions from the moderator and between the panelists. And then later in the session, I'll be asking the panelists to respond to questions from you in our audience. Now I'd like to briefly introduce and thank our co-sponsors, starting with Women in Bio, an organization of professionals that's committed to promoting careers, leadership, and entrepreneurship for women in the life sciences. The organization, and specifically its executive director, Jamie Strakota, suggested today's topic, and I'd like to thank her for recruiting our three panelists and together suggesting the topic for this event. I'd also like to thank the Licensing Executive Society, USA and Canada, for their support and making their members aware of this panel. In case you don't know it, for more than 50 years, LES has been the leading association for intellectual property, technology, and business development licensing professionals. Our third co-sponsor is the Biotechnology Industry Organization. Bio is the world's largest trade association in the life sciences arena and very aggressively supports the IP licensing and partnering activities through its networking and partnering events, its committees, and through various education programs. And finally, for those of you who are not familiar with ShareVault, we provide a cloud-based service that organizations in 47 countries commonly use for sharing intellectual property and other very confidential information that's being shared with outside parties. And because of our leadership in the life sciences arena, our service has been chosen by Bio and 33 other associations for their member benefits program. Okay, now we're ready to get started with our panel session. Today's moderator is Dimitra Georgianopoulou, the president of Women in Bio. Dimitra's involvement in the biotech space is extensive, starting with her MS degree in biosensors and a PhD in bioelectrochemistry, and her subsequent professional experience with Inverness Medical, Nanosphere, and Omics. She's currently the Innovation and Commercialization Officer at INVO, the tech transfer organization at Northwestern University. Dimitra, thank you for being our moderator today, and we're ready for you to introduce our panelists.
Thank you, sir, and thank you for everybody who joined us in this call. Like I was introduced, I am the president of Women in Bio, which is an organization that's mission is to invite, support, and empower women to succeed in the life sciences. And for that reason, we wanted to invite today three prominent ladies to join us in order to do a presentation on best practices for sharing IP rights in the life sciences. And what we wanted to do is to give you a perspective from three different points of view. So we have with us, and I'll go in details, Julie Watson, who's going to give us the perspective from a firm, a very established IP firm. Katie Murshide, I'm sorry, that is also to give us the perspective from an in-house patent counsel, who's of course now with a private practice, and finally a CEO of a life sciences company, Don Matthews. So in more detail, I want to tell you about Julie. So she is our special counsel at Marshall, Gersten & Boren, who's an IP-based, Chicago-based law firm. And Julie herself, she's a licensing professional that has over 25 years of experience, not only doing IP, but also structuring and negotiating complex deals that involve IP. And next, we have Kate, and Kate is currently the senior counsel at Morrison Foerster and has been doing patent prosecution, opinions, and diligence for over 35 years. But most importantly, she has worked as an in-house patent attorney at Syntex and Genentech before going into private practice. And then lastly, we have Dawn Matthews, who is the president and CEO of ADM Diagnostics, and she comes with 25 years of management experience in the life sciences industry. And ADM is a medical imaging technology company that helps differentiate classified dementias with PET scans. So she is also very involved in handling the IP and what it takes to have IP in order to be able to run your company as effectively as possible. So with this introduction, what I wanted to do next is I wanted to give these ladies their perspective about sharing IP rights. And what we'll do is we'll try and make this as involved and conversational as possible to get you engaged and keep you engaged throughout the whole time. So without further ado, Julie, please take it away.
Thank you very much, Demetra. I'm happy to be here. I wanted to start with the legal landscape that is involved when we're talking about intellectual property rights sharing. I'll begin with some level-setting comments that will refresh us on the concepts of what intellectual property rights are and what they allow us to do. Then I'll talk through some of the legal vehicles that we can use to share IP rights, and finally go over some of the rules of the game, the defaults in intellectual property rights sharing. So let me begin with refreshing us on what is intellectual property. Intellectual property are creations of the mind that are protected under the law. These are property that gain value from ideas, not their physical existence. And although they're intangible, they really are at the same time property assets of the business. Creations of the mind protected under the law. Some of this protection is through statute. Examples of that, patents and copyrights. Some established through use, trademarks. Others established through conduct or contract. Trade secrets, data rights are good examples here. So intellectual property rights, creations of the mind protected under the law. What big four that we are familiar with? Patents, copyrights, trademarks, trade secrets. Those are the ones we talk about most. But, next slide, let's not forget that's not all of the intellectual property rights. Things like domain names, mask works, databases can also be very valuable rights. So what protection does the law give this property? Not unlike real property. When you own property, what do you have? You have the right to tell somebody to keep out. This is my property, get off. Intellectual property rights provide fundamentally the same kind of right. Gives you the right to stop others from using that property. Of course, the inverse of that is, next slide, intellectual property rights can be used to stop. So fundamentally, creations of the mind protected under the law that give you the right to stop others from using the property or give others the right to stop you. We, for the remainder of the conversation, will be focused on patent rights. Patents certainly are front and center in the life sciences, and when we talk about intellectual property, I would say more often than not, what's in people's mind is patent rights. And talking about ways that IP can be shared, the legal vehicles, this really does apply to other kinds of intellectual property, but the comments are focused primarily on patents. Two major ways that companies can share intellectual property rights: licenses and ownership. In licenses, you have a permission. So I have the right to stop you. If I give you a license, I give you my agreement that I'm not going to stop you. So it's a permissive right that you get. Depending on what the license is, you may have rights to stop others as well. And that can go from none to quite a bit. For example, in a non-exclusive license or in a cross-license between companies, really what you are getting is the right to not be sued. I'm not going to stop you from using my property. There are co-exclusive licenses where maybe there's just one or two entities who have the right to use the property, and that may come with some rights to stop others from using it as well. All the way to an exclusive license for all fields, which may give rights to stop others from using it, almost equivalent to ownership. Turning then to joint ownership. Certainly, as an owner, you have freedom from being stopped. You do have the right to extend permission to others, so you have the right to license. And you do have the right to stop others, although as we'll see, it's really a joint right. Next slide. Talking then about the sort of rules of the game. In joint ownership, we want to look at what rights does an owner have, what are the rules that apply. And to do that in the United States, For the United States patents, ownership starts with the inventor. So under the law, it is the inventor who has ownership in the first place. Who's an inventor? An inventor is a person who conceives of at least one claim that is included in the patent. So we have co-owned patents when we have a patent where we have a single claim that was conceived by two individuals. We also have co-owned patents when a patent contains separate claims that were conceived independently by two different people. So you have the inventor as the owner, and an inventor is an individual who conceived of at least one claim. And if you have more than one individual either conceiving of the same claim or conceiving of different claims in a patent, you have a co-owned patent. What does that give you in the U.S.? Co-ownership in the U.S. is all or none. If you have an inventor with a conceptual contribution to only one claim, it doesn't matter if there's one claim in the patent or if there's 1,000 claims in the patent, they have that ownership right. And it's an equal and undivided interest. Each owner can make full use of the patent right. In the United States, that owner has the right to practice those patent rights, to license others to sell and assign, and without accounting to the other owner. So each owner can act independently. However, to enforce or to stop others from using the property, you need to have all the owners cooperate and come together. And why is that? Because if each individual owner can give permission, then in order to have a legal action where you're stopping somebody, you need to have everybody who has the right to give permission agree that they're not giving permission and they want to stop. Just by way of comparison, looking at what happens with patents outside the United States, a couple of things are notable in the rules of shared IP outside the United States. First of all, outside the United States, there's a lot more focus on applicants rather than inventors. Second, the co-owners require permission to license as well as to enforce. So in the United States, an owner can use their rights and let others use their rights independent of each other. That's not the case in many countries outside the U.S. Also, interesting point of comparison is to look at what the default rules are for copyright in the U.S. It's possible to become co-owners of a patent working independently. Not so with the copyright. Jointly owned work requires this intention to create by the co-owners. It's kind of an interesting difference. Still the equal and undivided interest in the copyright. And each owner has the right to practice and to license without permission. But here's the twist. The co-owners have accounting obligations to each other. So if one of the owners makes money off of their rights, they have an obligation to share profits with the other owners. Now these are the default rules under the law. And they can be varied, and in fact, they almost always are varied. We're familiar with employment agreements. So in the United States, intellectual property ownership starts with the individual. The copyrights, there's the work for hire concept, and so there's a statute that gives ownership to the employer to certain kinds of copyrights. With patents, that inventorship assignment to the employer is usually under an employment agreement or an employment policy. We're familiar with consulting agreements where an individual gives ownership of their patent rights to the company that they're providing consulting services to. And in a number of service industries, testing and R&D, there may be ownership assignment or lesser commitments under contract to vary the rules. So certainly by contract, the inventors can give ownership to third parties. There's also varying the default rules by joint ownership agreements. So if you have two entities who own the intellectual property together, they can decide by agreement that, for example, permission is granted for licensing outside the United States, or they can decide that one of the two parties will control patent prosecution. Some of these agreements can be made before or after the invention. In writing, of course, is always a good idea. Sometimes a written agreement is required, for example, in the CREATE Act, where you're trying to create a safe harbor for collaboration between parties. And there are a number of model agreements out there for parties to use when they want to vary the default rules and decide amongst themselves how they're going to handle joint ownership. One such model put forward through a working group for the Association of University Technology Managers. And so if you're interested in one, I know they have one on their website. One of the really challenging things in joint ownership is planning for changes over time. Intellectual property rights have a very long lifespan. When we think about patents 20 years from filing, and consider that out of the classes of intellectual property, that may have the shortest lifespan. And 20 years from filing, patent rights last longer than a lot of marriages in many cases. So if you're entering into a relationship around sharing IP, you have to have this long vision of not just how things are now, but how they may be as things change over time. Here are a few concepts to think about as you're thinking about how you're going to share your IP rights and how they may change over time. Assignment agreements and inventorship. Improvements. How are we going to handle if one of the parties makes improvements to the patented technology? Companies don't stay the same over time. What happens if your co-owner turns out to be somebody who's your chief competitor? And certainly bankruptcy is an issue. What if your co-owner ceases to exist and the assets are part of the bankruptcy estate? As an example, I've got here the issue of assignment agreements. So we have two inventors. They've conceived of an invention, contributed to a claim that's in a patent. And now we want to record the ownership of this through an assignment agreement. And there are really three ways we can go about doing it. Option one, we can have each of the inventors assigned to their employer. So inventor one assigns to company A, inventor two assigns to company B. The patent issues, it's owned by A and B by virtue of the assignment from the inventor. Option two, we do that. We have each inventor assigned to her employer, but then we have the companies do a cross assignment where they each assign to each other. Outcome, patent rights owned by A and B jointly. Or third, I could have inventor one assign to A and B, and inventor two assigned to A and B. And any one of those three options will end up with the patent rights in question being owned by company A and company B. What happens, though, if the scope of the claims change over time? If we used option one, and one of the inventors is no longer contributing to a claim, in option one, we had inventor one assigning to their employer, inventor two assigning to her employer. If one of the inventors drops out, so does one of the companies, and no longer is the patent co-owned. Contrast that with the outcome of option two and three. If one of the inventors drops out, we still have this cross-assignment between the companies, and it still will be jointly owned. Now, neither of those outcomes is right or wrong. It just depends on what you had in mind. So if the co-ownership was going to be by virtue of maintaining that inventorship, then you want to use the assignment option of each inventor assigns to their own company. If I'm no longer an inventor, it's no longer jointly owned. If instead what the agreement of the parties was, we want to own this jointly regardless of what happens during the prosecution, then you want to use option two or three. So that gives us a kind of a quick overview, a level setting of what these concepts are, the legal landscape underlying sharing of IP rights. Looking at changes over time, I think certainly I had the benefit of illustrating here one of the simplest cases. I think one of the more complicated issues that I see people working with is how to manage improvements. There's a jointly owned patent and an improvement is made to it or one of the parties, and so we have a jointly owned underlying patent but not jointly owned improvements. I'm interested, Dawn, from a business perspective, what strategies have you seen used and any thoughts on how to tackle this successfully?
Sure. Well, first, Julie, I'd just like to say that was a really informative presentation, so thank you for that. And I think that the background that you gave on really the legal rights that come along with patents and inventorship highlight the need to have structure around them, that you need a, kind of a contractual framework if you're going to expect to have any protections beyond each party being able to kind of go off by themselves. So in terms of strategies that I've seen to tackle improvements to the jointly owned patent, it really is context dependent. So I'll give you a couple of examples. One is our company, ADM Diagnostics, was actually formed initially as a joint venture. And so in doing that, we had to think through, what happens when we jointly invent improvements, both if we stay together and if we don't stay together ultimately. So one of the approaches that we use is that in our company, we have clearly a mutual interest, a mutual commercial goal. And so any improvements that apply to our business and relate to our business are owned by our core company, ADM Diagnostics. Other fields of use that may interest one of the parents, but not necessarily ADM Diagnostics, we have granted the right then to go off and pursue with a reasonable, payback or nominal royalty back to the company. In the event that the companies did not stay together, one approach is to say, well, basically, you maintain your core inventions, you cross-license any background IP that was necessary to practice those inventions, but beyond that, if you're really parting ways, it's maybe each for his own. The thing that I would probably just one last thing, the thing that I would watch out for is any agreement, for example, with a university. Sometimes, universities have default language in there, and something probably to avoid is a contractual term that states that any of your, let's say you've licensed technology from the university, let's say that anything that's invented, even if it's not a joint invention, which you can control by not collaborating on the invention of new improvements, but any new improvements are licensed back to the university or in fact owned by the university. That's maybe something to watch out for.
So I know that as Julie was putting her presentation together, I know the rest of the panelists and myself came up with some more specific questions for her for now. And please don't forget to keep adding your questions in the little box so we can address these at the end all together. But so, Julie, again, thank you for this presentation. One of the questions that I know has come up is that if companies are planning to share IP rights, what factors should they consider when choosing between licenses or joint ownership? I know you touched upon the different options, but what is it that makes them decide one way or another?
Certainly. I think that really, Dawn, you put your finger on the key point here, and that is to think about what you want to get out of it, where you're going. So you're going to have different attributes with a license than you are from ownership. And at first blush, you're going to think, if I want a lot of control, I want ownership. And if I'm comfortable with less control, I'm going to go with a license. And I really think that that's not the correct analysis. If you have joint ownership, you are joined at the hip for enforcement. And again, thinking about the lifespan of intellectual property. And, you know, if you do a comparison to real property, when a married couple owns a house, there's different property rights than when two unrelated individuals own a house. And the married couple own it jointly, and they have to exercise that right jointly, using that as a parallel. If that's the kind of relationship you're getting into with your joint owner, and understanding that for the next 20 years you guys are going to make decisions together, then ownership is a good vehicle. It's going to give you a lot of control, and you're going to be working closely with the other owner to achieve the outcome you want in terms of being able to stop others and being free from being stopped. Licenses are generally considered as a subset of the rights, but you really can craft them just about any way you choose. It is a contract, and it's an agreement between the parties. So if you don't think that the two parties are going to be in it together for the long haul, maybe you want to have one of the parties as the owner and the other party's rights and obligations spelled out in a contract. And I would say a third option is if you are concerned about the long term with somebody, but you want ownership, the joint venture is not, it is certainly a vehicle that you should consider, because that way the owner is neither one of you, but the two of you working together.
Perfect. Thank you so much for that. So, and then I know another question was, what about licenses and joint ownership? Does that happen? What happens when one of the owners licenses a third party to use the jointly owned rights? Are there any complications there?
Well, so this is an interesting concept, and I alluded to some of this as I went through the default rules. Yes, when you're an owner, you have a right to license others, and that certainly is something that happens. What happens, though, is the licensee of only one of the joint owners cannot be an exclusive as to all other licensees, because they don't have the rights of the second owner. And this, I think, is another illustration of how joint owners are signing up to work closely together over a long period of time. In the life sciences, exclusivity is generally considered critical to incentivize investment in the long haul for regulatory. If I want to give an exclusive license and I have a joint owner, for that really to be effective, I have to convince the other owner to give that license as well. So a joint owner can give a license, but it's not of the same breadth unless you're giving it together.
Perfect. Excellent. Thank you. Thank you again, Julie. So I think without further ado, maybe we can now move on to Dawn's perspective, again, the CEO of the License and an entrepreneur's perspective of this. Thank you, Dawn.
Sure. So I have, as Dimitra has mentioned, the perspective from a business standpoint. So next slide, please. Okay, so situations where IP sharing arises, we have the usual suspects, so co-development agreements, joint ventures, R&D collaborations either between companies or between an academic institution and a company, and then industry consortia. That one's a little more abstract, but certainly an example would be on the pre-competitive R&D side. The Alzheimer's Disease Neuroimaging Initiative has brought together a private partner scientific advisory board that consists of a number of different pharmas and service providers, all focused on Alzheimer's disease, but certainly fierce competitors off the field or on the field with one another. So that you have to kind of establish where are you going to draw the line between working together and perhaps inventing new ideas versus going off and then putting them in the competitive space. Standards organizations, and then one that might not be a, quote, usual suspect, but is certainly important as customer agreements, because, for example, in our business, we do imaging of the brain to help pharma companies understand how a drug is affecting the brain, but we may discover something about the compound. So even though it's really not structured intentionally as an IP sharing agreement, these concepts come up and we both must deal with them ahead of time so that we know what happens. Okay, moving on. So one thing that's just critical in structuring IP sharing agreements is really trying to make sure that it's balanced and protecting each party's interest. So, interest, plural. So one of the aspects would certainly be making sure that royalties, fees, payments to be made are reasonable, both, to assure business benefit on both sides. But a more subtle aspect of that has to do with the fact that if you have a player, a partner that strikes a deal, and perhaps they were in a position of power when they struck the deal, and they derive terms that are not necessarily as reasonable as one might like, it may down the line serve as a disincentive for the other party to either cooperate or to continue, perhaps if the other party had been licensing the technology, to continue to use the technology. So I think it's important to consider, do these terms reflect reasonable business terms, but also will they incentivize success for both parties? Protecting against stacking royalties is another one. You may need multiple technologies or multiple inventions as part of a successful market offering. And if these different, perhaps in-licensing agreements do not take into account the impact of additive royalties, it could ultimately become just not even viable from a business perspective. So that's certainly something to think about up front. Flexibility, I'll get into that in a little bit. Patenting costs, how are the costs going to be shared? Is there a cap on costs that each party will bear? Is there visibility, and are there approval guidelines for allowing that each party can approve what costs are incurred? And then thinking through the what-ifs, and this is certainly one of the most important aspects. I think sometimes when companies go into agreements, joint collaborations, joint ventures, licensing agreements, they anticipate that funding will come at a certain time, that the market, that the revenue growth will come at a certain time. And as we all know, life just doesn't always go as planned. And it's important to think about things like, what if the market projections are better than anticipated or not as quick? And what if, funding doesn't come in when it's supposed to? What if the joint collaborator or the joint developer incurs a delay in their development program? What is the impact of that? How will you deal with it? And I think thinking through these things up front and having contingencies so that there is continued collaboration, continued goodwill, goes a long way in helping a license agreement or a joint invention agreement to survive and be successful. So going on to the next slide, incentivizing cooperation. One of the things that we've found to be incredibly important is something that's very intangible, and that is the goodwill, the motivation of the parties that are involved or the individuals that are involved in both developing the core technology as well as improvements to the technology. And these might be researchers at a university. If they are not on board, or if your joint venture partners are not on board, things can fall apart pretty quickly. But if you keep people incentivized that they're part of the team, communication is regular, you have, kind of joint incentives, that you acknowledge what the other party's particular interests and priorities are. For example, the other party's priorities may be on publication, or maybe on, just being able to be at the cutting edge, or it may be their revenue stream, which would be kind of an obvious one. It's important to recognize those and try and maintain them. Something that also is an important aspect of cooperation is making sure that the activities that are pursued by one and both parties are respectful or consistent with the needs of the other, especially as it comes to publications and use of the technology for other purposes. For example, if you're working with another company or a university, it may be critical that they not go off and publish the work before you're ready, or use it in another collaboration where there's kind of reach through to a competitor. So these are all things that, if thought through up front and there's cooperation on them, can yield a successful relationship. So just moving on to the next one. What about deciding whether to license something exclusively or non-exclusively? You know, I think there's often a temptation, if there is technology to be had, or if you're going to jointly develop something, to want the exclusive, because that's, you know, who can argue with that? But there's a cost to it often, and that cost can be pretty high. And I think when Kate speaks, she'll give you some really good numbers on what these costs can be. So questions to ask are, is the technology a primary value generator for the company? And if it is, and if it's an important and fundamental barrier to competition, then an exclusive may be well justified. If the technology just offers freedom to operate or rounds out the portfolio, or if it's something where you already have an exclusive position that's protected, then a non-exclusive may well make the most sense and be much more cost effective. So next slide. We move on then to some questions about structuring collaborations and IP sharing. So I would like to direct this to my colleagues here, my panelists. One of the questions that often comes up is, you know, what is reasonable? We're going to do an in-licensing deal, it's a medical device deal, or we're out-licensing our software, or perhaps it's a compound. What resources and methods do you typically use to establish reasonable royalty and fee rates? And do you have a kind of a general range of rates that you see in both the medical device space and the pharma space? And that's a big topic, but I think any insights might be of interest to people.
And Dawn, this is Julie, and I would be happy to comment that. So, you know, the what royalties are used, what's the right royalty rate is a question we're always asking. And there is no number is the answer, but it's always 5. Any number of surveys over the years, there is something around 5%. So if you're in doubt, you don't know what number to use, it's 5. But that said, I really I see in the life sciences most folks have some kind of scientific background, and they like to do research. And I see a lot of people digging in and doing research on what our market comps, and looking less at what is the money to be made using this technology. So in the life sciences, I tend to see people looking to surveys. LES has a great royalty survey. Autumn has some royalty survey data. And there are resources out there to look at typical deals like this that have been used. There's also a number of good valuation models to help you tackle at a high level, is this a reasonable royalty based on how much money can be made? I personally have used those and see my clients using them. On the licensor side, I have found less interest. So a licensor will do a lot of data analysis and say, look, I did this and it looks like this is the right number. I've not seen that really persuade licensees over time.
So Dawn, thank you again for your presentation, which was very, very informative, and I know very interesting to all entrepreneurs in the audience. But can you tell us what have you found to be the most effective in maintaining a successful IP relationship, if there is such a case?
You know, again, I think thinking ahead, planning for the what ifs, making sure that when you enter into a relationship, you really have a good reason for doing it. It's really going to be a core focus. Making sure that you can resource it, because if you get into an IP sharing relationship and there are certain expectations, or you can't resource its implementation or its utilization, then you've just spent perhaps a lot of money or upfront time trying to do the deal and really not much payoff. I would say that despite any contract that might be in place, and contracts are certainly incredibly important, ultimately it really is a people relationship often. And so it's certainly with our joint venture, I can say that, and other collaborations actually that we have in place, it is the relationships and the communication that we have with our collaborators that make it work. Because once you have a positive relationship, you can pretty much steer the ship where you need to go.
Perfect. So you're saying, keeping in mind that it's people involved in its relationships that count. That's awesome. And then I think we have another question for you. What have you found to be the most notable challenges in academic licensing relationships? So please remember, I represent Northwestern, so please be gentle with us, but go ahead.
Oh gosh, no problem. So we love academics. I think that it's the challenges really relate to the fact that academics have, kind of, I think, a mission to invent, which is exactly why we love working with them, and to develop, to be on the cutting edge, but also to publish. And if they've never been in a company, it may not always be readily apparent what some of the pitfalls or dangers are in, openly sharing information or sharing technology or sending someone. I think it does boil down to communication and just making sure that people understand, what kinds of things are going to hurt the company if you go off and publish this or do that. Another, just one more challenge can be academic institutions may have, especially if it's a large multi-school chain, may have sometimes some onerous or maybe dated terms in place, and they can't always be that flexible. So sometimes that's a little bit of a challenge too.
That was excellent and gentle, so thank you. And I think with that, further ado, let's move on to Kate. So Kate, please take it away on patent strategies.
While we're waiting for Kate to join us, encourage the audience to submit questions based on the two presenters so far. And let me go through some of the questions, and we do have a number of questions that have come up. There's a question here, and Julie and Dawn, I'm not sure who's best to answer it. It says, please explain the process for provisional applications. Maybe Julie, do you want to start with that?
I certainly can talk about it generally. Provisional patent application is put in without examination to preserve your date, and you don't need to name inventors on a provisional patent application, and you don't need to have any claims. And so, thinking about the concepts we've talked about, at the time that you file a provisional patent application, you may not actually have made a determination of who are the inventors, because you haven't really made a final determination about the claim set that you're going to put in. The process is not too dissimilar from filing a patent application generally. Submit it with the Patent and Trademark Office. It sits there for a year and nobody looks at it. And then a year later, you either replace it with the utility application, the full application, or you don't. And if you don't, it goes away as if it never existed.
Okay. Dawn, anything to add to that?
Sure. I would just add that we are, in fact, in the process of filing our second provisional this year, or in the last year, and we have found it to be a very helpful process. And with what Julie was saying, that there are no particular claims, but you do want to make sure that adequate information, it's almost written like a patent application, because if it's too vague, it will likely have difficulty really being supportive of what you ultimately wanted to patent. In process, go ahead, please.
I was going to say, if I can jump in to really underscore that, a provisional patent application is going to give you a placeholder priority right but for what you filed. So if you have an incomplete provisional application in terms of description, it does not create a priority date for you. And so it is very important to make it as complete as possible. I know a lot of folks will do what they call cover sheet. And there's a cover sheet that you put on this, and they'll underneath that put something very skimpy, maybe an abstract or so forth. That's certainly better than nothing, but don't take false comfort from it. It may not be giving you the protection you think you're getting.
Second question here is, even in the case of joint ownership, only a single party can bring suit. Is that correct? And would an unfavorable outcome in a suit obligate both parties or only the party in the suit?
In an enforcement of your patent right, you need to have all of the owner's rights represented. So the idea that only one party can bring suit, I'm not sure what the concept is there. And so, for example, the typical situation is you have an owner and then you have an exclusive licensee. And it's this exclusive licensee who's out in the marketplace and has the most interest and investment in stopping the competition. And the exclusive licensee will therefore want to make the decision or not to enforce. In addition to the benefit of stopping others, there's the cost for the privilege of doing so. These are rights protected under the law, but you have to pay for them to be enforced. And I think that patent infringement suits, I think the rule of thumb now is it's sort of $1 million to get going. The owner may not want to spend that money, may not want to be involved day to day. Generally, the licensee will file suit and name the owner in the suit. When there are all of the rights, effectively all of the rights included in the license, the court may not require the owner. And however, there have been suits where the licensee goes in and says, all right, I'm enforcing, and the court says, no, you need the owner to join you. If a patent is held invalid, a patent is invalid. So when you say, is the decision binding, we're talking about whether or not the patent rights are enforceable. And if a court of law says they're not, then they're not.
Okay, thanks. Question here, and again, this may be applicable to you, Julie. What factors stand in the way of obtaining international life science patents? Is it simply a matter of cost?
We certainly have seen the element of time. I think this is something that in life sciences we're familiar with in the United States. A number of patents that might pen for 3, 4, 5. I've seen patents issue after 10 years of prosecution. And that varies by art unit, and the life sciences are some of the longest pending applications. My understanding, not my area of knowledge, is that that has a lot to do with bandwidth at the patent office and also the complexity of the claims that we're prosecuting. And laid over that is the changing law that affects the prosecution. If you've been following the Supreme Court, you know they've, over the last 10 years or so, taken an inordinate interest in intellectual property law. And when a decision comes out, it changes what the patent examiners sitting in Washington are doing. And so that trickles down to new process, uncertainty in the process, changing guidelines. I stopped keeping score, but I think we were at the 9th set of guidelines for the patent examiners on what's patentable subject matter. And certainly that slows things down.
Dawn, any comments that you have around international or going for international patents? Is that something that you're dealing with at your company?
Certainly, we have some decisions to make. It is very, very expensive, but also important. You know, if you have a patent that just applies in the U.S., at least in our business, it can be quite limiting. So we actually look to our patent counsel to help advise us on what, what countries are most important.
Am I on yet?
Yes.
Kate, yay!
Yeah, I don't know what happened. I could hear you before, and then he finally just dialed back in.
That's great, Kate. Well, we can hear you, and we'd love to move to your part of the presentation.
Okay. Well, I don't want to cut off questions but I'd love to talk.
Yeah, no, go ahead. I think we were wrapping up, and I appreciate Dawn's comments on the complexity of and the challenge of choosing cost, but also having protection more than just in the U.S. So I think it's
right. And I also heard her answer about provisional applications and how important it is to have a complete application, because one of the things that you can do to shoot yourself in the foot is to think that a provisional application that's sketchy is going to protect you against the publication, for example, of the scientific paper that is used as the provisional, which I've seen done. And then there's no opportunity to scope out the invention at all. You've basically shot yourself in the foot. So I want to reemphasize that. So I was asked actually to talk about the advantages and disadvantages of patents versus trade secrets as one part of the presentation. And so in an attempt to avoid the blindingly obvious and the hopefully obscure, let me just go through the first slide that is part of my presentation. The first advantage, of course, is this is a protection against independent invention by other people, that you can exclude people even if they've invented this independently. A second advantage is that it's a convenient tool for impressing investors, and one can easily share the patent position with potential investors. A third thing, and it's extremely important, obviously, for collaboration with universities and research institutions, is that having an adequately filed patent application permits publication of the work, whereas otherwise that would not be the case if trade secrets are relied on. Another advantage from the standpoint of the patentee is the incredible absolute exclusivity of stopping other people. In the United States and in most countries, it is not necessary for the patentee to be using the invention, but instead can use it to cut out competitors using technologies that might be competitive but not the same subject matter as the patent. And in my opinion, it's that level of exclusivity that has probably been a factor in creating this judicial exemption that I'd like to discuss briefly at the end of my presentation. We have no research exemption at all except for the exemption for work that's done in preparation to get regulatory approval. Whereas other countries do have some level of research exemption, so that one could use the invention, for instance, with the aim of trying to make improvements on it, but we just don't have that. We have absolute exclusivity. Disadvantages are there's a finite lifetime, although it's pretty long, 20 years from application. In the United States, there are extensions for delays in prosecution and time spent on appeal if you win. And it is very costly upfront and over the 20-year period, including annuities just to keep the application alive, which I will talk about a little later. So on the next slide is the advantages of trade secrets. I'm not a big fan, but there is a possibility of long duration as long as nobody reverse engineers the product or comes up with the same invention independently. And there are no really steep costs involved, although there are costs involved going through the lifetime of the trade secret in making sure that the secret is properly kept and documented. Disadvantages: no protection against independent discovery. It's hard to use this as a tool to convince investors, and of course you can never publish. And on the next panel, the question was raised whether one could, for example, apply for a patent on a general process, for example, and disclose it in general terms, but keep the little tricks that make it work to oneself as a trade secret, and somehow get the best of both worlds in that way. The U.S. is the only jurisdiction that does have a requirement that the best mode of carrying out the invention be disclosed. And when the America Invents Act was passed, failure to disclose the best mode was taken away as a defense against infringement, but the requirement was kept in the statute. So far, I haven't seen anyone do this, but it would be possible, I think, to challenge failure to disclose the best mode on the basis of inequitable conduct, that there's a statutory requirement that one willfully did not comply with. That would be a different standard from just the best mode as a defense, which is just isn't there. And here one would have to show actual willful withholding in order to make this an inequitable conduct defense. I also want to mention, because not everybody is aware of it, that it is not necessary to identify what the best mode is. The statute only requires, in cases of held, simply that the best mode has to be in there. So I suppose one could camouflage it by putting a lot of alternatives along with the best mode, and that would still comply. The next topic would be similar to what's been discussed, and I'll try not to be duplicative here, of protecting each party's interests where there's a collaboration and there may be joint inventorship, as opposed to, for instance, just a license where one party has already done the work and another party is simply licensing it. If there is this question of joint inventorship, as Julie pointed out, there are a number of ways that this could be resolved. One of them, and Dawn indicated that wasn't very desirable from a company standpoint, is to make the improvements decide in advance who's going to own improvements, decide in advance who's going to own inventions made with a compound that's owned by one party, and perhaps just decide in advance how the pie is going to be split. One thing that has happened to me a good deal is that there are disputes about what the inventorship actually is, and a third party could be agreed upon in advance that these disputes are going to be decided by an independent third party. And the other thing that I want to point out is that it appears that there's nothing that sours a relationship more quickly than to have one party go off and file a patent without telling the other one. So each party should be informed. And then the next panel talks about costs and benefits of patenting, and sometimes there's kind of a knee-jerk reaction, well, we'll just patent everything that comes along, and it's not a very good strategy. So I propose the three questions that are on this panel that one should ask oneself in order to decide whether it's worth the cost, and they're pretty perhaps self-evident: whether the business would suffer if competitors could use the technology, whether the patented subject matter could be monetized by licensing, that's typical of universities and institutions, and would the existence of the patent help get investors, which it just may from sheer numbers, just judging from offering memoranda that I have seen, which just list how many patents people have. Never thought that was terribly relevant, but it seems to make a difference. The next panel gives an idea of the costs of obtaining protection just to file, nothing more than filing, on a scaled back worldwide basis. And as you can see, it's pretty expensive. And I have not, this is not the worst of it. The prosecution costs, rule of thumb, I'm thinking 2 or 3 times the cost of filing in every jurisdiction. And there are annuities ongoing through the lifetime of the patent, which can amount to hundreds of thousands of dollars as the years go by. Moving quickly then to scope of protection and how to perhaps maximize what can be protected. I'm very happy with some results that we had with regard to what I would call layering, where a platform technology, which is very generic, has been patented, and then a particular species of that technology, for example, a commercial product based on that platform, has been patented, even though the platform technology is citable against it. And then in the case of a commercial product that is a drug, for instance, we were able to obtain protection just to specific protocols for using that commercial product. I think this is in contrast to evergreening, which people like to do, where the commercial product, somehow the patent's going to expire, so a new formulation, a new protocol, etc. Those are harder to enforce, harder to, most patents in the pharmaceutical field that have been invalidated have been in these evergreening categories. Last but not least, I wanted to just mention the quote-unquote judicial exceptions on the next slide, which is a big, big problem for biotechnology as well as for computer-related and business method-related inventions. Specifically, things like antibodies as pharmaceuticals, markers for diseases, protocols for testing for fetal defects, for instance, which was just invalidated by the Federal Circuit, are candidates for non-patentability due to this judicial exception. There are some defenses against this that can be employed right away. They're listed, the ones that I know about, on this last panel, and I'm running out of time, so I'm not going to talk about them. So I'll go to my question, and since I'm such a big fan of patents as opposed to trade secrets, I thought I'd ask my fellow panelists whether there are instances that they see that they think trade secrets would be useful in the biotech industry.
I can take a stab at that one. We actually do see a role for trade secret, and I can give you a few examples. One is if you think that the invention has a very limited life, so it's much more important to get out there, commercialize it, spend your resources getting it adopted, getting the revenue from it. If you think that you're going to surpass it, you know, in the time that it might take to get a patent anyways, unless it's fundamental to your future inventions. Another condition would be if revealing the information that you would have to as part of a patent really just invites people to try and design around or to find ways of surreptitiously maybe incorporating it without disclosing that they are. There are things like that, and we are definitely having to make decisions like that right now. Do we patent or not? Because we don't want to reveal too much. Finally, data. I just want to mention that any data sets that are used to develop something proprietary, it would be difficult to, but not impossible, to patent the data, but the value is often in keeping it trade secret.
Thank you. That's really helpful.
Thanks.
The question that I have for you, from me to you, Kate, is why is filing a scientific paper as a provisional application a bad idea?
I think we covered that already.
Okay, good. And then what do you see as a future for the judicial exception problem? And I know, and I don't know if you want to go back to that slide 43 and maybe talk about it while people are watching that. So, yeah.
Well,
yeah.
I don't think I need the
slide,
panel.
so the short-term solutions. Okay, good.
The short-term solutions are things that we patent applicants can try to do to overcome. What I see as what has happened is that the Supreme Court decisions that are said to be controlling have just been bent out of all recognition by both the Patent Office and the Federal Circuit. So I think what's going to happen is that somebody is going to, perhaps this Ariosa versus Sequenom case is going to be taken to the Supreme Court, and maybe the Supreme Court will see fit to take a case like that and clarify what they really meant by their decisions, because apparently what they've done in Prometheus and Myriad has just been interpreted out of all recognition.
So you're saying you foresee that there will be another case that will probably help them clarify what they really meant. Is that what you're saying?
I'm hoping.
Perfect. And then Steve, I don't know, we have a few minutes left. Maybe we have some questions maybe that are maybe targeted for Kate specifically, or I will let you maybe wrap things up. But thank you, ladies. This was phenomenal. Thank you, Kate. This was a very good presentation.
Thank you.
Yeah, we do have just maybe time for a couple of questions. Let me throw one out right away. When two companies have significantly different financial resources, how are patent costs paid for other than a 50-50 split?
By agreement, I think.
Any other comments?
I would agree.
Okay.
Yeah, I would agree.
Well, one of the things that I have seen used where one of the owners has a big patent budget and the other one has a small or non-existent one is to agree that the party with resources will front the costs and then recover them from any commercialization in a way that rewards them for the risk. So I'll put in $1 of patent costs, and then any revenue that is made off the patent rights, you'll repay me like a 3x a multiplier of my costs, so that I get some upside for the risks, but you don't have to give up the benefit of those patent rights just because you don't have the budget right now.
Another question here, I'm trying to get as many in as possible. Another disadvantage about trade secrets that you cannot prevent a third party from obtaining a patent on the subject matter and filing an infringement suit against you. Is that correct?
I think that's right.
Okay. Anything further on that, Kate? That's certainly
right.
A risk that you have by just going through the trade secret process.
Good point. Very good point.
Another question, when trade secrets and know-how are covered under CDA, do they expire with the expiration of the CDA?
Well, usually CDAs have provisions that the confidentiality provisions extend beyond the life of the agreement, sometimes a specific amount of time, like 5 years.
Okay. We have many more questions. I'll ask this last question here, and for the audience, if your question wasn't addressed, we will be sharing them with the panelists, and so you'll be, get those answers directly. Last question: have you seen a positive or negative shift in university tech transfer on company licensing with the advent of IP leveraging, and that's in quote, arms of universities?
I don't understand the question.
And I'm not sure I can elaborate on that, so I'll pick another one. And this is, I think, one that I believe that has already happened, but the question is, when will the U.S. change to first to file? Is there a movement towards that? Wasn't that part of the market?
That's been done.
Okay.
For anything, for applications filed after the effective date.
Okay. Well, Julie, Dawn, and Kate, thank you for your very enlightening presentations. You've provided everyone involved